What are the trustees' responsibilities? And how does a house that is in a trust sell? Those are some really broad and good topics that we're going to get into today. I'm Ellen Mitchel, your heels on the ground in the Miami-Fort Lauderdale area. And on this channel, we're going to talk about everything probate, guardianship, senior relocation, and more. Remember, I am a residential realtor. I am not an attorney, so anything that I say is from my experience and my work with attorneys. Always seek the guidance of an attorney for legal advice. So in terms of selling a property in a trust, someone's going to create a trust during their lifetime. They're going to do this with an attorney, hopefully. The trust is going to appoint a trustee and a successor trustee. The trustee is the one who will carry out all of the duties of the trust. I'm going to use my family as an example. My mother had a living trust, and I was the trustee. She had put her home, which was her largest asset, into the trust, as well as all of her accounts. Her IRAs, her brokerage accounts, bank accounts, everything. So when she passed as the trustee, I was able to handle all of the financial matters of the trust. That doesn't mean that I inherited everything that she left. In the trust, she designated who would be inheriting and what. And my role as the trustee was to follow her wishes and administer the trust. So it was a lot. She did have a home, and we did decide, in my situation, my sister and I decided we were the sole heirs, and we decided to keep the home and to rent it. So we had to take it out of the trust and set it up in LLCs in our names, and then go about getting the property empty. That would be part of the trustee's responsibility, removing the personal property from the home, distributing any personal property that was left in the trust, if there were jewelry, if there were mementos, if there were china, if there were crystal, anything that was left to different family members or organizations. The trustee's responsibility would be to distribute those according to the trust. And then the bank accounts. It's really important that the trustee doesn't close everything out until the end. So I had to make sure to leave enough money in that trust account to pay the bills of the trust until it was finished. What does that mean? My mother had a car, so until we sold the car, we had to keep insurance on it. She had a home. There were utilities to be paid on the home. There was monthly maintenance. All of those things had to continue to be paid, property taxes. And so I had to make sure that I left adequate money in the trust in order to pay those expenses. So I couldn't just turn around and cut a check and distribute the proceeds of the trust 50-50 to my sister and I. It's a really big responsibility, and I would suggest consulting with an attorney when you're named trustee. A trust also bypasses probate, so it does not go through probate if it's in a trust. So you don't technically need to work with an attorney, but I think it's a very, very good idea for anyone who's made trustee to work in conjunction with an attorney to make sure that they're not running any red lights and that they're doing things in accordance with the law of the state that you're in. The trustee what is the difference between the trustee and the heir? The trustee is the person who's responsible for administering the trust, paying the bills of the trust, distributing the personal properties. The heir are the people that the trust is giving those items to. So in my mother's case, it's my sister and I, we were the heirs. So my sister and I were both heirs to the trust, but I was the trustee. And then typically you'll have a successor trustee listed. If there was any reason that I could not fulfill my role as trustee, the successor trustee would step in and do that. Even though I have a lot of experience with this, I did consult an attorney as I was going through this process, just to make sure I wasn't running any red lights and I was doing everything in accordance with Florida law, just to double check and make sure that everything was done properly. I chose to be very transparent about everything because for me, I think that's the best way to do things. It avoids a lot of misunderstandings and mistrust that can often come about when you're talking about financial matters. So if you don't want to go through probate, if you want to avoid probate, then you need to get with an attorney. A estate planning attorney is the appropriate attorney to get with, and they will help you prepare a trust that you can put your home in, all your bank accounts, your retirement accounts and everything, and that way you can avoid probate and it's a much smoother process. So although we chose not to sell the home that was in the trust, I sell homes that are in trusts every day. It is the trustee that will sign the listing agreement. It is the trustee that will sign the sales contract. It is the trustee that will sign all of the documents at closing. It is important when it is a trust sale to make sure that you're getting legal advice and that everything is being done the way that it should be. So again, I can't stress enough the importance of getting with a good probate, guardianship, or estate planning attorney, an elder law attorney, so you have that partner with you every step of the way, the estate planning attorney to prepare those documents, and then a probate, guardianship, or elder law attorney to help administer the trust or the estate after the time of death. I hope this clears some things up, and I'm sure it may bring up some other questions. So if you have questions, comments, or just anything you'd like to hear more of, please put those in the remarks below, and please don't forget to like and subscribe.